Hello. We were talking last time about how to write and use a letter of formal notice. So it's only logical to continue this topic by the question, how do you respond to a letter of formal notice when you receive one? First of all, it's necessary to remember that a letter of formal notice, even if it's written by a lawyer, it's just a letter. It's not a document sent from the court. It's not a court order. It has, normally at least, it has no value or force over a judicial order. So you treat it as such, as a letter. So, what are your options with respect to that? Well, the first one is clear. You can do nothing and wait until the other party, the author of the letter, would do or would not do anything after that. Because it's not impossible, it's not unusual when the letter is sent just for the intimidation purpose and nothing happens after. Because one thing is to make some pretense in just a letter, another thing is to bring the same to the court as your official court application. There might be consequences if the allegations are completely unfounded. So, if you think that the letter is nothing more than just sorry bullshit, then you simply just wait and see what happens next. If you think that the letter is written in good faith and that the idea is to keep you informed about some kind of a problem, and you think that the other party might stop there if you respond with a good argument or something, you could choose one of the other options. You could choose to respond with a simple denial, saying that no, I deny all your allegations. It didn't happen like that. I don't owe you anything, something like that. In short, of course, because you should not volunteer information. You should not admit anything. You should not promise anything. You should not accept anything, at least in your response to a letter of formal notice, unless you really mean that, of course. But normally, if you think that the allegations in the letter are false, you can simply deny. If you think that not everything there is false and that probably it's a good idea to try to avoid any further litigation or just extended conflict, you might respond with some proposition to negotiate the situation without admission again, but just as let's discuss, let's see where we can go from that. Sometimes it's clear that there is a letter that the other party wants something from you, but it's not clear what exactly or why, or there are some vague threats or allegations, but you don't really know what is it all about. So you can respond with questions like, please clarify. What do you mean by this? What do you mean by that? What kind of proof do you have with respect to that and that? So that if the other party replies to that, you would have better understanding of what's going on and how you should behave in the circumstances. If everything is quite clear for you, and if you really think that the other party is trying to settle the conflict in good faith, you might come up right away with an offer saying that, well, I can give you this amount, for example, I can do this and this in exchange for you dropping all the allegations. And usually, if this goes anywhere, it ends up with a so called transaction, meaning an agreement which has more or less a force of a judgment in the sense that after having that transaction, at least in Quebec, you cannot go to the court after with the same allegations. So transaction in that sense puts an end to a conflict. You might prefer to go aggressive. Then you just respond. If you respond, of course, you respond with a counterclaim, saying that, on the contrary, you owe me because of this, this, and this, and you explain why. So it's a response with another letter of formal notice of sorts. And finally, if you think that it's a continuous campaign of defamation or intimidation, or you've just simply got fed up with all that, you could initiate your own lawsuit, of course, if you have grounds for that. So those are your options. I wouldn't say that the usual response is spread equally among all those 7 options, and that there is no way to combine them one way or another. But I would say that significant majority of responses are simply going with the first one, like do nothing and wait. No way that I recommend that. Every case is different, and if you really need to understand what to do, you'll probably have to consult your own lawyer. But at least that's an option. So you should know that even if you received a letter of formal notice, it's not absolutely necessary to respond to it. But you might, as well, you might, especially if you want to negotiate. So this is it. Thank you, and have a nice